Welcome to In the Name of the Law, with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Amy Bailey from Bailey and Terranova Attorneys at Law, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law, a legal talk show about real people and real legal problems. Today's episode will explore how eyewitness testimony frequently misidentifies perpetrators in criminal cases. We'll discuss a fascinating case where a family sued a vacation rental property after the husband was shot while on vacation. And we'll discuss why you should settle your custody or divorce case. Please stay tuned.
In the name of family law.
Good morning. Today we are talking about settlements in family law cases. I have with me Amy Bailey and Erica Terranova of the Bailey and Terranova Law Firm. And I wanted to ask, why is settlement or compromise so important for custody cases in particular?
For custody cases, there is a lot of emotion involved in these cases. And if you can, with the other parent, settle some of these issues, it goes a long way for the lifetime that you're raising your children. One problem is how expensive it can be, Lisa, is the cost of ongoing litigation is extremely expensive. And I think it's best if the parties are able to save some of that money, settle their issues, and then be able to save that money to maybe spend on their children. And settling custody cases, you know your children better than anyone. You know your children better than the employees with friend of the court and the judge as well. So the two parents, if they're able to sit down, come up with a schedule that works for them and their children, that is going to make their family run as smoothly as possible in two different households.
So, Erica, it sounds like maybe you can settle some issues, if you could settle some issues in custody parenting time, but if there's just this one or two things that are hanging out there, I think, is the judge going to be appreciative that the parties went through the process to resolve most of the issues?
Absolutely. The judges do encourage settlement, and you will go through a friend of the court process that certainly tries to get you to settle those issues. But the more issues that you can narrow down for the court, they are pleased. They can see that the two of you can work together. And there are sometimes one or two lingering issues that the court has to decide, but they do certainly appreciate you narrowing down the issues.
And the court sees that the children also would be aware of the fact that their mom and their dad have resolved this issue and that mom and dad are working together. And of course, children like that. They don't want to see mom and dad competing. If they do not resolve the issue, as Erica mentioned, you are involved then with the friend of the court, which a lot of people get afraid of, but actually they are very helpful. The very first step would be, if you can't resolve an issue, you would meet with the friend of the court for an investigation. And that's where mom and dad go in and meet with a caseworker, and they try to resolve their issues. If they cannot, that friend of the court caseworker will make a recommendation. And what parents have to be aware of is that that becomes the order of the court that they have to follow, which again, that's why we try to encourage parents to resolve these issues between the two of them so they don't have to rely upon this third party that does not know them. That's also where their child or children would be interviewed. And parents, they don't want that either. They want their child to stay out of it as much as possible, which we all do. If you do not like what happens at that friend of the court investigation level, parents are given the opportunity to object within a certain time period. Well, but in the meantime, they have to abide by that order that's in place, and then you ultimately go in front of a referee. As Erica indicated, this is a very expensive process because at the referee level, that's where you're having witnesses testify, you're introducing exhibits. It's a very, very important step, however. If you do not like what happens at the referee level, you have the opportunity to object, and then you ultimately get before your judge. So it's a very lengthy process, and we like to lay out for our clients the cost as well as the time so that they can try to resolve those issues between the two of them.
And are there special considerations that would really push parents to say, you know what, I really don't want a judge to decide this? What kind of examples can you give us?
I would say examples of, we have children that have special needs. The two parents are able to address what those special needs are and should know how to accommodate those special needs. the court may not have the knowledge unless we provide it to them as to what that specific child needs. They might have a special talent. They're involved in a sport or a art, let's say, that really takes up a lot of time, that the parents are really the ones that know the schedule and should be the best ones to do that instead of letting the judge decide.
Well, let's switch to the other types of issues that come up in divorce cases, which is property division. What types of issues can come up in those property division settlements?
Well, I was just discussing with Erica about a case where the parties owned an airplane, and that their kids were all grown, so this airplane, that was their baby. And they fought over that airplane. It was essentially a custody case. But again, you know, you have an airplane. It's not like you can cut it in half or anything. You have to decide one of you is going to receive it and buy the other one out, or you're going to have to share it. But we ultimately were able to resolve that issue, but it was with a lot of time being spent trying to figure out who was the better pilot and all those types of considerations. And the other issue that we're seeing more often now it's for pets. I mean, they're very, very close to their pets. They love their pets, and they don't want the pets to be divided up. They want the pets to stay together. And you hear about, well, I'm the one that bought this pet, and I'm the one that takes care of the pet. But then the other parent has the opposite side of the story. Courts don't want to hear about custody cases for pets. And so we try to encourage settlement of those issues as well.
So can you tell us a little bit about the role of the mediator who comes onto the case?
In our courts, it's very, very common for judges to encourage or order even parties to attend mediation. That's a situation where you have a mediator that is essentially in charge, listening to each side of the case, each side of their story. The party appears with their attorney if they have an attorney. You usually set forth what your position is in a mediation brief beforehand, so the mediator is aware of exactly what the issues are. And that's your time when you don't have the rules of evidence, they don't apply. You can essentially tell your mediator what you want them to be aware of. And again, you have to come to the table with your compromise hat on to try to resolve these issues so that you do not have to proceed to the next step, which would be a trial.
So are there any special rules if one of the parties is a victim of domestic violence?
Definitely. That's a mediator is required before they even start that mediation process. They have to inquire if the police have ever been contacted, if there's been any domestic violence. Does the party feel intimidated at all? Are they comfortable in this process? Do they feel that they can resolve the issue without having anybody else trying to encourage them or tell them that this is what they have to do? That's a very important piece of mediation.
And so if the mediator has concerns, are they supposed to stop the mediation from happening, or what's the result here?
If there is concern that it is not an appropriate case for mediation, then yes, that mediation process would stop.
Okay. Well, thank you so much for your time today.
Thank you, Lisa.
In the Name of Family Law is brought to you by Bailey and Terranova Attorneys at Law. In the name of criminal defense.
We're here with Takura Nyamfukudza and Mary Chartier from Chartier Nyamfukudza, and we're going to talk about eyewitness testimony that comes up a lot in criminal cases. So let's talk about the misconceptions that there are related to eyewitness testimony.
So many people think that eyewitness testimony is rock solid, but it's actually one of the leading causes of wrongful convictions. And what people think about eyewitness testimony is just not what the science and history shows.
So you were going to tell us about a pretty famous case that had to do with a false identification from an eyewitness.
A woman named Jennifer Thompson selected a man who raped her. She selected Ronald Cotton out of both a photo array and then an in-person lineup. And she said she was 100% certain that he was the man who raped her. She said he was 3 inches away from her face and she would never ever forget that face. Well, she was wrong with her identification. He spent 11 years in prison. DNA ultimately exonerated him. What's really remarkable about the story is Ms. Thompson had tremendous guilt for misidentifying the wrong man. And the real rapist was allowed to walk free all those years while an innocent man spent all that time in prison. But Ronald Cotton, just like so many exonerees, ultimately was able to forgive her. And they formed this amazing friendship. They wrote a book called Picking Cotton. They've lectured all around the country, and their story is actually being made into a movie.
Wow, that's amazing. So I have a question about the identification. Is there a comparison of did they find out who the real perpetrator was?
Well,
to compare the two faces?
What's interesting in that case is the issue of cross-racial identification. And Takura has lectured on witness identification quite a bit. Right. So I know you can talk about that. But frequently when you have a Caucasian person or an African-American person and they're identifying someone of a different race, the ability to make that identification goes down significantly. And that's what happened here. Jennifer Thompson is Caucasian, Ronald Cotton is African-American. So she picked the wrong man out of the photo array. Then she picked the wrong man out of the actual in-person lineup.
Let's talk about in-court identifications.
Right.
So,
yeah, go ahead.
Absolutely. Well, a number of times we've had somebody say, "Oh, yep, it was definitely that person." But again, like we said, with cross-racial identification, things like, goodness, tattoos, those often come up, and that played a significant role in a case that we tried. But so often, when these cases eventually get to trial, they're often separated, unlike on Law and Order, right, where it's from commercials are all that separate, the incident and the trial. Sometimes it's years between the incident. Memories fade, and a lot of these issues, when police officers, for example, put photographs in front of people, we try to suggest that it not be the same officer who perhaps arrested the individual, so that there's no suggestion. Are you sure that this isn't the person? And that's called double blind. But yeah, a number of these factors play a role in that.
Well, you mentioned being close in time to when the incident happened. So if you have a photo array, don't they usually do that pretty close to when the crime occurred?
It depends. I mean, it depends on the case. Sometimes it may be hours or days after. Other times it may be months or years after. When you were talking about in-court identifications, though, you have to remember the client is sitting at a table frequently with a placard that says defendant in front of it. And then you ask a witness to look around the courtroom and say, do you see the man who stole your purse or assaulted you or whatever it may be?
There he is.
Right, there he is. But even with that, there have been some really funny stories. We had a teenager who was a witness who looked around the courtroom and then looked at the defendant at the table, who was African-American, looked at the judge, who was also African-American, and said, him? And then, everybody burst out laughing because it was not the judge. And another situation where we had multiple defendants and multiple lawyers, and the witness looked at one of the lawyers and said, that's the guy, right? That's the guy who was involved in the big drug distribution. And it was a lawyer. It wasn't even the client.
I was just going to add, there have been some creative attorneys, although not many judges would allow this, who have actually allowed somebody else, not the accused, to sit at the table just to see whether this person's memory is what they claim it is.
We've had some cases where witnesses have been communicating with each other when someone has been unsure about, especially when you have multiple defendants, who is who. And then you'll have one witness and then they'll communicate with other people to say, okay, well, the guy on the end, that's the one who did this. The guy in the middle, that's the one who did this.
Let's talk for a minute about photo arrays or lineups when you have to identify the perpetrator from a lineup.
So this may seem obvious, but not so much. Color versus black and white photographs make a difference, because what to me may be a light or dark black man may be different to you, right? And we also want to make sure, so for example, it should be all men.
Oh, we had a case, though, where our client was African-American, and the photo array that they showed, they said, well, the witness picked him out of this photo array. When we asked to get the photo array, there were 2 Caucasian women, one older Hispanic man, 2 other African-American men, but probably 10 to 20 years older than our client. So, what a shock, right? They picked the only person who was remotely like the individual who they claim committed the crime.
And there was a recent federal trial where the police actually doctored the tattoo on the individual's face that was in the photo array.
To make it look more like the person they thought was the perpetrator?
Yes.
There are a lot of best practices, but it's up to police whether they're going to follow them or not.
Right.
The state of New Jersey has been really at the forefront of mandating some best practices and actually holding hearings when there's been an issue of eyewitness identification. Michigan is very far away from that right now.
And it's up to you guys to defend the Constitution.
It is.
So thank you today.
Thank you. If you're interested in hearing more about eyewitness identifications and other issues that relate to constitutional law and criminal defense, check us out. We are Constitutional Defenders. We're on cndefenders.com. We're on iTunes and other podcast platforms. We've got lots of great stories for you to hear. Thanks, Lisa.
It was great having you on today.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
Hello, I'm here with Steve Sinas today, and we're going to talk about some unique aspects of personal injury cases. Steve, people think that personal injury cases are simple. Is that true?
Well, they can sometimes be simpler than others, but oftentimes the way in which people are injured brings up all types of legal issues or issues that are relevant to people's rights. So if an injury occurs in a certain location, there could be different laws that apply depending on how the injury occurs. Then you get into insurance coverage issues, who the defendants are, where the case is going to be litigated. And so, all of a sudden you have a case that involves a particular injury, and it's very complicated in terms of figuring out how to handle it. And I'm really happy and proud to have my partner, Jim Graves, here, who's had just a stellar career overall and has handled so many complicated personal injury cases that have involved strategy and great workup and really stick-to-itiveness to actually get it done. So I'm happy to have him here, and he's going to talk to us about a particular case involving somebody who sustained a catastrophic injury at a rental property, actually.
Okay, well, Jim, can you tell us about what happened in that case?
I'd be happy to, and thank you, Steve, for the introduction. This is a very unique case and one that I found to be gratifying as an attorney. It's always very gratifying, of course, to secure a successful recovery for a client. But in this particular case, given the unique circumstances and the catastrophic injuries and the difficult legal and logistical problems that this case presented, made it all the more gratifying. And what started out as being a family vacation should have been a very festive and joyous occasion, turned out to be tragedy for the family and with permanent injuries resulting in paraplegia. What happened was the couple from Michigan with their children decided to take a warm weather vacation in a Caribbean location and invited their extended family to this particular vacation. They were going to celebrate New Year's and spend a week in this warm climate. So actually the grandparents searched online of the various booking sites that we all use and are familiar with. And they found a property that looked online to be safe, secure, inviting. It was well maintained. And so they booked it. They signed a contract and the family went there. And for the first couple days, they had a lovely time. But on day 3, regrettably, gang members invaded the property with masks, with guns. They held them up. And our client, my client, who was a 42-year-old husband, father, did what people would do, tried to intervene to protect his family. And unfortunately, he was shot through the chest in the point blank with his wife standing there. Fortunately, he wasn't shot in the heart, but he suffered a very severe injury to the spinal cord and was rendered a paraplegic. So he was airlifted out of the country where they were staying, brought back to the mainland, underwent major surgery and years of rehabilitation, and to this day is living with his family in Michigan, doing quite well from a psychological standpoint despite the catastrophic nature of the injuries. But the recovery that we were able to make for him was so important for not only himself but his entire family, to give them the security and the financial wherewithal to be able to take care of his medical needs, his physical requirements, the specialized wheelchair and other apparatus that he needs to function every day.
I can tell you this, though, it was not an easy road to that recovery for Jim and the clients.
Yeah, tell us a
No.
little bit about how the case was handled, what kind
Right.
of unique issues came up in this case.
Sure. Well, to start with, most people would say, well, where's the legal claim here? Why would these people have a right to sue anybody? These were gang members. As it turns out, with investigation, we learned that the location of this particular beachfront property was in the most dangerous part of the island. It was a drug-ridden, gang-infested area. These people had no reason to know that, our clients. But the owners, particularly the wife of the couple that owned the property, she was from that area. She moved to Chicago from the island, so she knew what was going on in that locale. So we determined that the site on which the grandparents found this location was not truthful. It was really false what they were representing in terms of security. So we brought a suit against the property owners, the couple, who, as it turned out, were retired. They were former educators. They lived in Chicago. We brought the suit in Chicago, where our firm has an office, and I'm a member of the Illinois Bar. We filed suit in Cook County Circuit Court against the property owners, claiming that they had misled the clients in terms of misrepresenting the safety, that they didn't have proper security, and that it was foreseeable that something bad could happen like this on that property.
Did anybody else get sued, or was it just the property owners?
Just the two property owners, the husband and wife, at first, right. Now, here's where there was a twist in the case. The insurance company for the property owners, that company is located on the same island where the property is located. The insurance company took the position that there was no insurance coverage for this loss. They said, number one, we won't defend you, the property owners are insured, and even if there is a judgment, we'll never pay it because we believe you were operating a business. And in fact, if you look at the policy carefully and you walk through all the various provisions, and it is complicated and it is convoluted, we were able to maintain successfully that it wasn't a business, that they used it as a residence also. So we sued the property owner, but the property owners had no defense. They had no one to come into court and defend their position. They had to hire their own lawyer.
Because their insurance company wouldn't do it.
Because their insurance company wouldn't pay for a defense. So this couple hired their own lawyers, a very fine firm in Chicago, but they could only afford to pay their lawyers for 6 months going on a year, and they ran out of funds. And so at that point, it was a matter of what do we do next? Now, my client had no interest in pursuing these people personally and trying to obtain their assets. That was not what we were trying to accomplish. We wanted to have the insurance company pay our clients for the negligence of the property owners, but we couldn't get the insurance company to cooperate. As it turns out, they had a very small policy. So we ultimately obtained a default judgment for several millions of dollars. I'm not going to talk about the specific amounts, against the property owners, and then we sued their insurance company, and it ended up in federal court in Illinois. And the reason we were able to sue the property owners' insurance company was that we had the insurance claim assigned to our client. And so there were all types of issues involving venue, choice of laws. I spent a week on the island with an interpreter deposing all the insurance people there, and finally we were able to get the case settled over a period of 2 days of mediation.
Wow.
Several years, though.
Right.
And lots of work, so
Lots
it
of
does
work to
take
help out
a
your
long
client.
time sometimes to get that justice for the client.
Well, thank you for sharing your story, Jim.
Sure, thank you.
Your client story.
Right.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thank you for joining us for In the Name of the Law. Today we had some really interesting cases that we discussed, from suing a rental property owner, misidentification in eyewitness cases, and also settling divorce and custody cases.
Well, there's more than meets the eye when it comes to the law, right? So we hear about whatever field of law we're talking about, and people may have their own conceptions about how things really go with cases. Jim Graves, I was so happy to have him on. I mean, he's had just this career of fighting these unique circumstances, and so the rental property case was such a unique case. It basically turned into a bad faith insurance case. So it went from a rental property owner to the insurance company, and there's so many things that happen in that case. So when you hear about a case and what's happened, know that there's a lot to it, and that it's not so simple, and it often takes years to get a result for a client.
A lot goes on behind the scenes.
Yes, yeah.
And I think Amy would agree with that, right? With the settling divorce cases and serving as a mediator, right?
Definitely. As we talked about, we encourage clients, parties to try to resolve their cases, settle their issues. This will save them time and money, and it also brings the parties together to solve their issues rather than having a third party who does not know their circumstances, does not know their children, make that ultimate decision which could impact them the rest of their lives. And we talked about the lengthy process, the steps that they have to go through, but if you can come together, compromise, and work out your differences, it'll work well for everybody involved.
And we also talked about how unreliable eyewitness testimony is, right, Takura?
Right, and as Jim Graves' case goes to show, and many we've handled, they beg the question, is seeing truly believing? And again, these unfortunate circumstances manifest themselves not only in cases like that, but thousands of people have been behind bars and will continue to be in the future because, again, we know that we're not that good at identifying people, and certainly it bears even more so when it's cross-racial.
Wow.
And when it comes down to pursuing truth and justice, we all try so hard, if we're witnesses, if we're lawyers, if we're jurors, but sometimes it's hard to figure out what really happened. And so I think any area of law you're practicing in, you have to know that while people might want to find the truth is difficult to determine. So you have to always take things with a grain of salt, always press harder to know why something was said the way it was, what witnesses are really saying. So there's a lot of work and effort that goes into that, I think, as an attorney especially.
Amy, is that what you're doing when you're in mediation? You're pushing people beyond their comfort level?
Right. Well, I mean, we want them to understand when they're coming to mediation, both parties need to compromise. You're not going to get what you want 100%, nor is the other party. So we want to try to bring you together, something that you both feel comfortable with when you walk out of there.
And I would hasten to add that as unfortunate as these circumstances may be, some people are truly saying what they believe happened, right? It's not malicious many times.
And I'll say this, I say this sometimes, technology helps us do so many things these days. What we quite haven't figured out, though, is people and the way people interact with one another. And whether it's disputes and divorce, identifying witnesses, we haven't figured out that people issue yet. And that's why there's so much litigation, that's why there's so many disputes. So,
great observation, Steve. Thank you, everybody, for the show today.
Thank you.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.